Thanks everybody for joining Lift Louisiana this evening for our review of the recent Supreme Court term. We have a great, robust discussion for this evening. I'm going to put in the chat, but if you have any questions along the way, please enter them in the chat and we will do our best to answer them. So this evening, we are going to unpack how the court ruled on these major cases affecting reproductive freedom, rights for LGBTQ plus folks, immigration, and the role of federal courts, and what it really all means kind of moving forward. Again, if you have any questions, please put them in the chat, or we'll have a Q&A session at the end where you can unmute yourself. We have muted folks, so we ask that you just stay muted so that there isn't background noise that interferes with other people's ability to hear the presentation. So this evening, you will hear from me. I'm Michelle Ehrenberg. I'm the executive director at Lift Louisiana, where we are working to build a better Louisiana for women, girls, and gender expansive people. And we do that by advocating for reproductive health, rights, and justice. And my co-presenter this evening is our esteemed staff attorney, Alex Moody. So the first case that we are going to talk about is Mahmoud v. Taylor. So this case is about a Maryland school district's decision to include LGBTQ plus reading materials in their curriculum. So these are storybooks for young people that have, LGBTQ plus characters and themes. But they were included as part of language arts curriculum, according to the school board. Some parents wanted to opt their children out of this instruction on the grounds that they had religious objections to these storybooks. And while the school initially provided opt-outs, it became really unworkable. They couldn't actually, especially in the elementary schools, really create separate time and space for language arts curriculum for groups of students whose parents didn't want them to participate in classes where these books were being used. So I just also want to note that just the idea of having a bunch of students whose parents have opted them out of their classes, removing those kids from the classroom during instruction, also made the kids that belong to the queer families feel like their friends didn't want to learn about their families. So this was problematic on both ends. So the question that came to the court is really like, do the public schools burden parents religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out. So in the oral arguments, a lot of the focus was on, whether this instruction was just merely exposing the kids in the classroom to the idea that queer and trans people exist in the world, and like some of their experiences, or was the use of these storybooks actually coercing children in some sort of way. And so the justices really talked a lot about whether just showing the books with these characters and these themes forces students to adopt certain beliefs, or if it's simply presenting diverse viewpoints. For example, Justice Jackson during oral arguments asked, what if, the children have a teacher who is gay? Would you want the parents to be able to opt out of, having their kid in a classroom just because the teacher's gay. So there were a lot of questions about like kind of where we draw the line. And particularly I would say, liberal justices, Justice Jackson, Justice Kagan, Sotomayor, were, concerned about this sort of like, how far can these parental opt-outs go before they are actually undermining public education? And that, a broad rule could really open the door to schools getting in a position where children are opting out of all kinds of topics that may be discussed in a classroom, like women's rights or divorce or evolution or interfaith marriages. Some of the oral arguments.
Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute. The reservation is about...
Can I finish,
counsel,
please? It has a clear moral message.
So I played that just to show you that this was sort of, part of the line of questioning, and what it seemed like the conservatives on the court were really concerned with. The oral arguments were really quite frustrating, and there was a lot of conversation around concern that the conservative justices, including Alito, had about what the kind of message that was being presented, and also a lot of misunderstanding about exactly what these storybooks, what they were about, and it was, there was some presentations from both the attorney representing the parents, but also the attorney for the Trump administration that joined, and were really kind of throwing out a lot of pretty extraordinary like claims, and likening this to being similar to teaching students, or exposing students to pornography. It was pretty disheartening. So the decision came down 6-3, and it was written by Justice Alito. And so in his decision, he concluded that using these books does substantially burden the parents' religion, and that the school districts really didn't have a compelling reason for not offering opt-outs. So that according to this opinion, if parents object based on religious concerns, then they get an opt-out, and there's really no limiting principle here. The decision that Alito wrote really pushed this, this concern about the books carrying what he called a normative message that same-sex marriage and being transgender are okay. But and he's like very aggrieved about the books presenting acceptance of same-sex marriage as a perspective that should be celebrated and should be honored by everybody. So really, the opinion does seem to suggest that just merely exposing children in public schools to content that religious parents object to, burdens their ability to, in the free exercise of their religion. And there obviously was a strong dissent that was written by Justice Sonia Sotomayor, and that dissent was joined by Justices Kagan and Justice Ketanji Brown Jackson. And Sotomayor warned that The decision threatens the very essence of public education because it strikes at the core premise of public schools that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. The dissent warned about a slippery slope if parents can opt out of LGBTQ plus themed storybooks, that they may also request opt out for other things like lessons about women's rights, or again, divorce, interfaith marriage, or even topics in science like evolution or climate change. So the ruling really does tilt towards accommodating individuals' religious convictions, even if they are limiting students' exposure to diverse viewpoints or even, fully accepted scientific principles. Okay, we're going to move on to the next case, which is Trump v. CASA. So this is the case about Trump's executive order ending birthright citizenship. And if you haven't read the order basically says that for a child born in the US to be considered a citizen at birth, at least one parent must be either a US citizen or a lawful permanent resident, like a green card holder. And so, citizenship would be denied to children whose parents are unlawfully present in the United States, or children whose parents are in the US legally, but only on a temporary basis, like they have temporary protected status, or they're here with a student or a tourist or a work visa. So obviously this order, most people think, very blatantly disregards the 14th Amendment of the Constitution that provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. But the case actually didn't center on the issue of birthright citizenship. Rather, it really focused on universal or nationwide injunctions, which prohibit the government from enforcing a law or policy anywhere in the country. And there, have been sort of debates on both sides about the sort of overuse of universal injunctions to kind of thwart the actions of presidents. President Biden also found lots and lots of the things that he was trying to do being blocked by these universal injunctions. So, there is space for a robust debate on the use of these universal injunctions, but this seems like a very strange case because it was so obvious that this executive order was a clear violation of the 14th Amendment to almost anybody that looked at it. So that was really the topic of conversation for the most part during oral arguments. The Trump administration argued that these universal injunctions are unconstitutional judicial overreach. And the Solicitor General, John Sauer, he also opened his arguments by saying that, he didn't think that this EO violated the 14th Amendment because the 14th Amendment was only intended to apply to the children of former enslaved persons, which is an interesting take. And there was a lot of discussion about whether class actions are more appropriate. And so class actions, can be difficult to organize people and find people that are similarly situated to kind of organize them to kind of join together to bring lawsuits. There have been a considerable amount of limitations on certifying classes over the years. And so there was some skepticism from at least the liberal justices and even maybe some of the conservative justices about whether class actions would be more appropriate, and using those would be able to apply a court ruling to people who are similarly situated without applying that ruling to every single person in the country. I think that Justice Elena Kagan was, really concerned about whether a class would even be able to be certified, and whether that would allow a group of people whose rights, their birthright citizenship was being violated by this executive order would be able to get relief. And the Trump administration's lawyer would not, he did not commit to like saying, well, if this case against this executive order was brought as a class action, like we would be fine with that. No, instead, he was, hedging and basically said, we would probably object to a class action as well. And he also had an interesting exchange with Justice Barrett, whether she asked him if a court of appeals ruled against the Trump administration, whether the Trump administration would follow that court of appeals decision and recognize that the people, at least that lived in that appeals circuit, would be protected by that court ruling. So, for example, if the Fifth Circuit Court of Appeals, which is the one in which Louisiana, Texas, and Mississippi are included, whether they would follow that Court of Appeals decision if it went against them. And the Solicitor General for the Trump administration was like, generally we would, but maybe not. I mean, it was wild. But the state's lawyers argued kind of the practicality of what denying birthright citizenship would mean for them, because they said that it's just it's really impractical to have groups of citizens who groups of people who are born in other states where their citizenship is not recognized, but then they move to a state like New Jersey where their citizenship would be recognized, and it puts an administrative burden on a state like New Jersey to then have to, basically, certify citizenship for all of these people. So I'm going to play also just a clip of Justice Kagan from oral arguments in an exchange that she had with the Trump administration's Solicitor General.
I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result? Does every single person that is affected by this EO have to bring their own suit?
Yeah, so this is like the fundamental question. If a court can't say this executive order is unconstitutional and I am blocking you from enforcing it everywhere in the country, or even just in this circuit, then you're putting basically people in a situation in which every individual is going to have to go find a lawyer and go to court and try to get the judge to grant them relief on an individual basis. And that is obviously going to mean that a lot of people's rights aren't vindicated in this country because not everybody has access to a lawyer. And even in the case of, bringing class actions, not everybody is going to be included in that class. So a lot of people are going to be left out. But nonetheless, that is basically the decision that came down. So the decision was 6-3, and it was written by Justice Amy Coney Barrett. And again, it didn't decide whether this executive order is constitutional. Instead, they rejected the concept of these nationwide injunctions, and not just in this circumstance, but this ruling is really broad and really puts, calls into question whether whether the judiciary has any ability to protect people's constitutional rights on a broad scale. So this is really, probably going to result in a patchwork of legal protections, not just in the case of birthright citizenship, but for a whole host of other, other rights that we rely on in this country. And it really puts the executive in a position where they can kind of do whatever they want, and maybe they'll lose in the Sixth Circuit, or maybe they'll lose in the Ninth Circuit. But if they don't lose in the Fifth Circuit, then they can enforce, their unconstitutional agenda in that part of the country. It's really troubling. And of course, there were both concurrences and dissents, because this was quite a complicated issue that the justices had a lot to say about. I want to highlight a couple of points from Justice Thomas's dissent, concurrence, in which he was joined by Justice Gorsuch, because his concurrence basically said, okay, so just so you lower courts know, you should not be doing universal injunctions anymore. And I'm calling this the F around and find out concurrence, because it basically, the whole thing was just don't get crazy, don't try to issue these universal nationwide injunctions anymore, or we will come in and set you straight. I mean, very explicit, the Supreme Court has all the power, and you other courts just need to step back, and you don't really get to do any of your judging anymore. And then Justice Alito's concurrence equally was a little bit alarming, because his really questioned whether states ever have a legal right to bring lawsuits and assert claims on behalf of their residents. And he also went pretty hard against this idea of class actions, and said, that he's very concerned about class actions, and he would reject class certification in a lot of circumstances. The quote unquote liberal justices obviously dissented. Justice Sonia Sotomayor read her dissent from the bench. And basically, she said every court in the country who has reviewed this executive order has deemed it patently unconstitutional, and that the opinion of the court in this case renders constitutional guarantees basically meaningful in name only for individuals who are not, parties to a lawsuit regarding that particular constitutional violation. And the practical effect of this means, and she says, quote, affected children risk losing the chance to participate in American society altogether unless their parents have sufficient resources to file individual suits or successfully challenge the citizenship order in removal proceedings. So she really laid out very clearly what the implications of this ruling are. And then Justice Ketanji Brown Jackson wrote a separate dissent and really brought home the implications of this ruling beyond just the birthright citizenship case. So Jackson warns that allowing the executive branch to act unlawfully against non-suing individuals, so people who can't hire a lawyer and go to court to have their rights vindicated, and that this undermines the very foundation of the legal system, that laws are only going to apply to people who can bring lawsuits, and they're not applying equally to everybody in the country. She says, quote, the majority's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. So it was a pretty stark warning to the country about what exactly this case portends. Okay, that is the end of my two cases, and I'm going to turn it now over to Alex.
Thanks, Michelle. I'm really happy to be here with y'all tonight. Sorry about the snafu earlier. The first case I want to talk to y'all about tonight is the big transgender rights case from this term. And regardless of the outcome of this case, this was a momentous occasion. It was the first time that an openly trans attorney advocated before the Supreme Court. So even though the majority opinion did not come out the way we wanted, it's still a huge moment for the LGBTQ legal movement and trans rights generally in the US. So the central issue in this case involved laws passed in Tennessee and Kentucky banning people under 18 from accessing gender-affirming health care. Gender-affirming care for young people tends to include things like puberty blockers, or for older teens, hormone replacement therapy. Almost all legitimate medical associations and decades of research support allowing young people to access these treatments if they need them. So the plaintiffs here are a group of transgender teenagers, their parents, and their doctors, and they're arguing that the healthcare bans violate their constitutional rights under the Equal Protection Clause of the 14th Amendment. So beyond the impacts that this case has on the ground in Tennessee and Kentucky, it also has serious implications for the equal protection doctrine, which will have like ripple effects into civil rights law more broadly. So we want to get a little bit more specific about what that means. So we do need to get a little bit into the weeds of the equal protection doctrine. I know we have a few other attorneys on the call, so welcome back to Con Law 101. So the Equal Protection Clause is meant to protect groups of people who are being singled out for discriminatory treatment under the law. However, states pass discriminatory laws all the time. For example, laws setting the age that you can get a driver's license or the drinking age discriminate on the basis of age. Zoning requirements single people out who live in certain areas for differential treatment and different regulations for their housing. Most of the time, in these kind of cases, an equal protection challenge, the government only needs to show that the discriminatory law is rationally related to a legitimate state interest in order to survive that lawsuit. However, when a law discriminates on the basis of a protected characteristic, the government has a much higher burden to meet to justify why they passed that law. So the list of characteristics that qualify for this heightened level of scrutiny has evolved over time, but currently the courts apply the highest level of scrutiny to laws that discriminate on the basis of race, national origin, religion, and alienage. And then we have the second tier of scrutiny called intermediate scrutiny that we apply for laws that discriminate on the basis of sex or legitimacy of parentage. For any law that's being reviewed under this heightened standard, the government has to show that they had a really good reason for passing the law at issue and that using that discriminatory classification was closely related to that important interest. This is just a higher burden that they have to meet in court to survive an equal protection challenge to that law. The plaintiffs in Skrmetti made two arguments for why the bans should be reviewed under heightened scrutiny. First, they argue that the bans on gender-affirming care discriminate on the basis of sex, which would put them in that intermediate scrutiny category, because the treatments that are at issue here were widely available to cisgender kids who need to access them. To give you an example of this, a cisgender girl going through precocious puberty could be prescribed puberty blockers, whereas a transgender girl who wants to access those exact same medications to treat her gender dysphoria would be denied access. The argument then runs that because the transgender girl is being discriminated based on her sex assigned at birth, this is sex discrimination, and therefore we should hold it to a higher standard of government justification. They also make an additional argument that transgender status should itself be a protected characteristic that warrants heightened scrutiny. The majority opinion only really deals with that first argument, that gender-affirming care bans operate in a way that discriminates on the basis of sex. So we don't end up getting any kind of binding decision on that second argument. The defendants, on the other hand, argue that rather than discriminating against trans kids on the basis of their transgender status or on the basis of sex, the bans discriminate against them because of their medical condition, being gender dysphoria. So to explain this with the same puberty blocker example, they argue that the bans discriminate against kids with gender dysphoria as opposed to kids with precocious puberty. And because medical condition is not a protected characteristic, they should only be reviewed under that deferential rational basis review. They do kind of dance around the fact that the kids who have gender dysphoria do tend to be trans, but that was the main gist of their argument. Get the next slide. Okay, so the decision was 6-3, and the breakdown was, the usual suspects with the conservative appointed justices in the majority and the liberal appointed justices in the dissent. The majority opinion does two main things. First, it rules on whether or not the bans should be reviewed under this heightened scrutiny. And then once it announces the standard, it goes on to apply the actual legal test to the facts at hand. So Justice Roberts wrote for the majority and found that the bans do not discriminate on the basis of sex and therefore shouldn't be subject to heightened scrutiny. He also pretty confusingly goes on to hold that the bans also don't discriminate on the basis of transgender status. He sides with the defendants that medical condition is the discriminatory like category that they're using rather than trans status. And then in the second step, he applies the rational basis review and concludes that because legislators had some uncertainty about gender affirming care, they had a rational reason to ban access for minors. I also just want to take a second to reiterate here that every major legitimate medical association supports access to gender affirming care for minors. And many of them actually submitted amicus briefs with a lot of evidence in this case, which Justice Roberts chose to ignore here. All right, so let's talk about what this means on the ground and also what this doesn't mean on the ground. So the immediate effect is that youth gender affirming care bans in Tennessee and Kentucky can remain in effect. This means that trans kids living there will either have to travel out of state or stop care or not be able to start care when they would like to. But it operates much like an abortion ban in that like folks with resources to get out of state to get their kids care are able to do so, whereas folks without may just have to suffer tremendously because of the law. On a brighter note, though, the majority does not address that question of whether or not trans status is a protected class, which I think is kind of rationally a weird take, but it does, as a silver lining, preserve the ability to continue to argue for heightened scrutiny for trans folks in the future. So this legal argument is still on the table for us, which is great. I also want to point out that the majority opinion was limited only to the record before it. So it only applies to the bans in Tennessee and Kentucky, and it doesn't immediately apply to other bans in other states, such as Louisiana. We passed a similar ban in 2023. And this leaves open the possibility for us to continue to bring legal challenges against that ban. And just to be extremely clear, this is not a nationwide ban, and it doesn't extend any existing bans. It just allows the existing bans in Tennessee and Kentucky to remain in effect. Can I get the next slide? Awesome. So we had two concurrences. One was written by Justice Barrett and joined by Justice Thomas, and the other was written by Justice Alito. The concurrences argue that the bans do, in fact, discriminate on the basis of trans status, but they go on to say that discrimination against trans people is actually fine and doesn't trigger heightened scrutiny. The overall tone of the concurrences is really dismissive of the historical and ongoing discrimination against the trans community, and they echo a lot of the current transphobia that we're seeing across the board in public discourse. So proceed with caution if you're planning on reading these concurrences. We also had a dissent in this opinion written by Justice Sotomayor, joined in full by Justice Jackson, and in part by Justice Kagan. All three agree that the heightened scrutiny would have been appropriate because the bans discriminate on the basis of sex. And Sotomayor and Jackson go on to discuss how the court should have applied the heightened scrutiny to the laws at issue and like decided that merits issue on the case. Kagan files an additional partial dissent saying she would have sent the case back down to the lower court to assess the actual merits of the case under heightened scrutiny. This is not like that legally important because it is in a dissent, but it does highlight an ongoing trend of Kagan showing reluctance to go quite as far as her other liberal appointed colleagues and more willingness to meet her other conservative appointed colleagues in the middle. So that's just something to keep an eye on as we go into this next term. Right. So the next case I want to talk about is Medina versus Planned Parenthood. Unlike Skrmetti, this case is likely to have a more immediate effect on the ground here. So we're going to talk about what it's going to look like in Louisiana specifically, as well as the broader impacts on legal doctrine and the ability for individuals to use the legal system to enforce their rights. So Medina is a case about Medicaid. We have a federal statute that establishes the Medicaid program, and it includes a provision that allows recipients to choose to receive health care from any qualified provider who accepts Medicaid. Basically, you have a right under this federal statute to pick your own doctor. The issue here was that South Carolina passed a law to exclude Planned Parenthood from the Medicaid program entirely. And Planned Parenthood is now arguing that the state violates that free choice of provider provision because Medicaid recipients who would like to receive care at Planned Parenthood, who is a qualified provider, no longer can. South Carolina argued in response that the language of the free choice of provider clause does not actually create a right to choose your provider, and that Planned Parenthood or any individual person or entity doesn't have that a private right of action to challenge that law in court. So there's kind of the two pieces to it. One, they say you don't have a right, and two, they say you can't privately enforce this federal statute by suing the state. It has to be like it has to be enforced by the regulatory body and not by private litigation. So the argument about the lack of rights creating language, that first argument took up a lot of airtime in the oral argument and prompted Elena Kagan to get a little spicy. And she just kind of lets the attorney arguing for the state know that she thought his argument was weak. So I wanted to play a little clip of that just as a little bit of levity.
I don't even know how to say this line without saying right. Has a right to choose their doctor. That's what this provision is. It's impossible to even say the thing without using the word right. Has a benefit to choose their doctor? The state has to ensure that individuals have a benefit to choose their doctor. The state has to ensure that individuals have a right to choose their doctor. That's what this provision is.
I remember watching the oral argument and just thinking like, yeah, like that's the amount of frustration that I feel hearing people argue about like that, you're not reading the words on the page that you're actually reading. But unfortunately, the majority opinion was authored by Justice Gorsuch and joined again by the usual suspects, with Justice Thomas writing a separate insane concurrence. The majority held that the freedom of choice provision does not unambiguously confer a right onto Medicaid recipients to choose a specific provider, and that the Medicaid statute doesn't clearly give individual recipients the private right of enforcement. This is kind of just, they gave South Carolina everything that they were asking for. This means that you can't bring this individual lawsuit to enforce your right in this kind of case. And instead, you're limited to file a complaint with the federal enforcement agency and hope that that agency decides to take some action against the state to force compliance with the federal law and allow you to access what's yours by federal right. So let's talk about some of the more immediate implications of this decision. States are now allowed to restrict Medicaid funding to Planned Parenthood clinics and other providers that they may either dislike or ideologically disagree with. With the loss of this revenue, it's possible that some Planned Parenthood clinics will have to close or scale back their services. And looking at this with a broader lens, this is part of an ongoing trend of increasing the power of states to exert control over bodily autonomy and personal healthcare decisions. We've been seeing this kind of across the board. I also want to highlight the fact that a lot of these fights over bodily autonomy happen in the Medicaid space because it's easier to regulate and pass laws about Medicaid as a government program as opposed to regulating private insurance. But the impact of this is that any bad to come of this, any bad policy passed, has a disproportionate impact on low income or otherwise marginalized folks who are on the Medicaid program. And finally, this is going to impact the ability of individuals to bring lawsuits to enforce their own rights in general against states. And it will just make it harder for individuals to get redress when the state violates their rights. In terms of what it's going to look like for us in Louisiana, unfortunately, our Planned Parenthood announced last week that they're planning to close the two clinics that we have, the one in Baton Rouge and the one in New Orleans at the end of September. I'm not sure how or if Medina played a role in having to make that heartbreaking decision, but I know my heart goes out to all of my colleagues at Planned Parenthood. We love you and we appreciate you, and we know this can't have been an easy week. But beyond Planned Parenthood itself, one of my main concerns here is that the decision might empower legislators to cut funding for other providers that they don't agree with. And the first thing that comes to mind for me is that gender-affirming care might become a target. We haven't seen any efforts to do that yet, but it's just something that might be on the table now in a way it wasn't before. All right. So in addition to the majority opinion, we got a separate and frankly shocking concurrence from Justice Thomas. He argues that private enforcement rights should only be available in cases where the right at issue would have been considered a privately enforceable right in 1871, which is when that initial statute, like giving people standing to sue state actors, was passed, which is pretty insane and very concerning when you consider who didn't have rights in 1871, namely non-white people, women, disabled folks, anyone besides white landowning men. And also just thinking about what the concept of rights was and how that's changed in legal doctrine over the past many, many years. So unsurprisingly, none of his colleagues signed on to this opinion because it's a very like fringe far-right legal theory. Um, but it does indicate that Thomas is not content with how much of a power grab the majority opinion already was, and that he would have gone further. This is pretty consistent with his behavior in other cases. He often writes separately to pitch these super conservative legal theories and say often some very out-of-pocket things. So again, this wasn't surprising, but it's very troubling because it's giving these types of theories airtime at the Supreme Court, and doing so gives them legitimacy. And even if they're not becoming the law by being in the majority opinion, they're still getting this kind of credence by being involved in like getting airtime at the Supreme Court. Okay, so we got a dissent from Justice Ketanji Brown Jackson. It was joined in full by her two liberal appointed colleagues. We don't have time today to get into all the details of her argument, but if you're interested in the nuts and bolts of the private enforcement question, she provides a really fantastic counter argument to the majority. And she just really highlights the reality that under the majority opinion, even in cases where an individual's rights have clearly been violated, even if everybody agrees that the state violated an individual's rights, it's still going to be much harder for that person to challenge state actors in court in order to get redress for that violation. Can I get the next slide? Awesome. Okay, before we wrap up on Medina and go to questions, I want to clear up some potential confusion around what's going on with the federal budget bill, and especially how it relates to funding Planned Parenthood and other reproductive health care providers. So I'm sure y'all have seen that the new domestic policy bill bars Medicaid funding going to providers that also provide abortion. Given the Hyde Amendment, federal money is already not going to cover abortion services, so this impacts exclusively like STI treatment and cancer screenings and just all the other types of care that these healthcare providers are providing. Yes, bless his heart indeed. So we have this new policy in place, and it's already being challenged in court by Planned Parenthood Federal as well as the state affiliates
Thomas
in
writes
Massachusetts.
separate.
Oh, go ahead. Oh, okay. Anyway, so this bill has been challenged in court by Planned Parenthood Federal and the state affiliates in Massachusetts and Utah. And thankfully, a federal judge blocked enforcement with a preliminary injunction. And while this is really great, the suit itself only deals with that like federal law. It doesn't have any impact on Louisiana or state ability to control Medicaid funding in like that state pile of money. So apologies, I know there's a lot going on, but this is just to highlight that like they're coming at Planned Parenthood from a lot of different angles, regulatory, legal, in the courts. So we're always dealing with a bunch of stuff.
Thank you, Alex. We appreciate you all joining us and sticking with us while we navigated our annotation bomber, which has never happened to us before, but I guess we can't be so complacent in Trump's America. But we figured it out. I learned something new on Zoom tonight, and we hope that you all also learned something. And we will see you next time. Thank you so much.